Sundar Singh to give his remarks.
His Lordship, the respected chairperson, honorable judges, my dear friends, when a prosecution starts, it is a very big debate within the legal fraternity itself. If the prosecution starts with the occurrence or the prosecution starts with an information. When an offence is committed in the dark, unless and until it is informed to the authority, it is not possible to initiate prosecution. For that only we have a number of police stations in our state. Amazing buildings, fully furnished with table and chair. We have mighty officers sitting there. And they are appealing to the society and say, if you have any problem, come with your complaint, come with your information, we will take care of it. Normally they get thousands of complaints daily. Nowadays most of them are related to husband-wife issue. But in reality, they are not going to get any information or complaint about the existence of bonded labor. Because bonded labor will not come and give a complaint or information. How a bonded labor can give information to the police? Because they are already under captive. It is not possible for them. That's why my first problem in the prosecution is, if the system is waiting for the victim to come and give a complaint, it is not possible to achieve the justice to be done. So there should be a new system to develop, where the police will not sit and wait for the victim to give complaint, where the system too should go and get and visit and find the victims to initiate prosecution. That's my first point. Once the information is given to the police, normally for the bonded labor issue, in the grassroots level, it is little difficult for the police to register the case. Irrespective of all the laws, irrespective of all the guidelines of Honorable Supreme Court and Madras High Court, already there is a stigma. There is a traditional things are there. There is a big confusion whether bonded labor is a crime or it is a labor issue. That's why they are little bit reluctant to file an FIR. Bonded Labor System Abolition Act Section 22 says it is a cognizable offence. Irrespective of this, the FIR is not being filed. The Honorable Supreme Court of India, in People's Union case versus the Union of India, the Honorable Supreme Court given observation that bonded labor is a contemporary form of slavery and it is a human rights violation. And the Constitution itself, Article 23 says, trafficking for labor is a punishable offence. And in the year of 2013, our Indian Penal Code is amended and added 370, and all the ingredients of bonded labor is included in 370 and highlighted is as a labor trafficking. And the punishments are enhanced up to life imprisonment. Still, the grassroots level, there is a feeling that it is not a crime and the FIRs are not being filed. And also, People's Union for Civil Liberties versus State of Tamil Nadu, there is a specific direction to the Tamil Nadu government by the Honorable Supreme Court of India. In that order, paragraph 8, it says, initiate criminal prosecution against those who commit bonded labor offence. But most of the time, the FIR, the cases are not being registered. That's a very big issue. So, my second point here is the confusion about whether it is a crime or it is a labor issue. That should be sought out, and there should be a strong monitoring mechanism should evolve to make sure that the prosecution is initiated. Once the FIR is filed, then the next ceremonial thing is recording the statement under 161 CRPC. As you all know very well, normally bonded labor case, the government of Tamil Nadu has evolved with a uniform procedure with the guidelines of Honorable Supreme Court of India in Bandhu Mukti Morcha versus Union of India. And in that it is stated that it is the sole responsibility of the revenue division officer in the capacity of subdivisional executive magistrate. He should exercise his magisterial power and he should go and conduct inquiry. On the basis of that inquiry, he should decide whether he is a bond laborer or not. For that, they say when a subdivisional executive magistrate visit a place, don't wait for the statement of the victim, because they are incapable to tell their stories. They are not a story writers. They don't know the ingredients of Bond Labor System Abolition Act. So you just ask some questions, and out of their answer you decide whether they are bond labor or not. In that uniform procedure itself there is an annexure. In that annexure there is a question and answer format is given. So normally some of the revenue division officers are here. They know very well. They will go to the spot and get answer. They will record all the statements in the question and answer format. This happens in 10 o'clock in the morning. Then they will be identified as bond labor. Information will be given to the police. Police will come after 4 hours. They say, tell your story. You want to record it under 161 statement. Is it possible? When the state government says in the morning, they are incapable of telling their story. But within 4 hours, that the statements recorded under 161 statement, is it possible for the victim to narrate his story? So most of the time, these 161 statements are a gate pass for the accused to get acquitted. They are welcoming it. They are using this document to contradict the entire case and get acquitted. There should be a new system to evolve for bond and labor cases. When the statements are recorded in the 161, should be recorded in a question and answer format, or the statement already recorded by the revenue division officer should be conducted as the 161 statement. And as you all know very well, that identification of bond and labor is the sole responsibility of the revenue division officer and the district magistrate. Normally they go after getting information, they will just conduct an inquiry, statements are recorded, then they will pass the executive order, inform to their boss, collector, and then they will give a lease certificate, and after that they just give an initial rehabilitation and get an acquittance. Lot of revenue documents are there, and photographer will picturize the issue, and most of the thing will be published in the newspaper. All these documents, there will be poor documents in the revenue department. I got opportunity to do a very small research in the prosecution of bond and labor system. I noticed that most of the 99% of trial cases, none of these revenue documents are added as in the court bundle, and none of them are marked. That means either the officer, investigation officer is ignorant on that, or is it not possible for them to get the copies from the revenue, or there is missing of coordination between revenue and the police. And that is my next problem in the prosecution. For that I am appealing once again that unless there is a very strict procedure to evolve, where the police and revenue should work together to attain and reach the end of conviction. And normally the huge problem for the victim is in the witness box. I have noticed some of the cases that once the trial is started, once the summons is served to the victim as a witness, it is a huge problem for them, because immediately the accused will go and approach them. Once they are coming in the witness box, and these victim witnesses for quite long time they are under bonded labor system, uneducated, and most of the released bond labels are tribal people, and they will be placed in the witness box and will be mocked like anything. And their innocent answers, everybody will laugh in the court. And you know, in the witness box, some 10 to 15 advocates will be around them, and they will hold the hands on the witness box, and one person will screw the victim with lot of questions. I read some article that in the better democratic countries, for the victims, at the time of cross-examination, the advocate who is conducting cross-examination cannot come near to the witnesses. If they want to come near to the witnesses, they should get permission. That's what they call it as approach permission. But we don't have that system. So they are coming close and threatening, and somehow they will get from the mouth of the victim that I am not a bonded labor. It is not easy for them to get acquittals. That's a very big challenge for them. This also to be addressable. And finally, I will wind up by telling one important thing. Few months back, the Madras High Court has started a scratch level discussion about the procedure of appointing special public prosecutor and the prosecutor. On behalf of the victims and for the better future of this country, I appeal this forum that conversation should continue forward, and I believe that this conference will get it reached on that. Thank you so much.
May I request Mr. A.R. Rahulnath IAS to honor Mr. David Sundar Singh by handing over a memento.